not filed by me. When the petitioner came to me, I told him that you can't seek a direction to Parliament to make a law. So therefore, my lord, I sought permission to amend the petition. Permission was
And instead of that, now you are using the expression implement.
No, we are saying respondents to issue a writ, order or direction to the respondents to implement an independent and transparent system for appointment of members on the election commission on the lines recommended by these various commissions. 5 commissions which went into it. But I am now today, my lord, in my oral submissions going one step further. I am saying that these commissions recommended a selection committee consisting broadly Prime Minister, Leader of Opposition, all of them say. In addition, there is some difference. Some of them say Chief Justice, some of them say Speaker, etc. I am going one step further in line with the NJSC judgment. The NJSC judgment says that, look, this system where the main stakeholders also play a role in selection of judges, though the dominant people may be independent, but if the main stakeholders also play a role, then that will be amenable to give and take, which is not good for the independence of the judiciary. I am saying the same thing with regard to the Election Commission. Today, my lord, Election Commission, the main political parties are the main stakeholders before the Election Commission. They are the main stakeholders. And therefore, in my respectful submission, the system should be selection by a totally neutral body. Now, what that neutral body could be, I have said. One option is the Collegium of the Supreme Court, just as they select judges. The second option is that you can have 3 senior judges of the Supreme Court along with, let's say, the existing Chief Election Commissioner, the Chairman of NHRC or the CAG. I am mentioning these authorities because at least they enjoy functional independence. Tomorrow, my lord, after your lordship's direction in this case, assuming that we succeed, the election commissioners will also enjoy independence by way of selection. And once that happens, then of course, my lord, the Chief Election Commissioner can certainly be in the selection committee, or the outgoing Chief Election Commissioner, if this selection is of the Chief Election Commissioner, certainly be on the. So therefore, my lord, this would be, in my respectful submission, a neutral body where the main stakeholders do not play any significant role. And that will ensure. The argument is this, my lord. Free and fair elections is a basic feature of the Constitution. Democracy, basic feature of the Constitution. Now, if it is felt by this court, which has plenary powers under 142, that in order to ensure the independence of the Election Commission, it needs to be selected by some independent body, then, my lord, this court has in so many cases given such directions. In the case of police reforms, Prakash Singh. In the case of CBI reforms, Vineet Narayan. In the case of judiciary, Skora. In the case of electoral reforms, that ADR and that PUCL cases, where the court said that, well, in order to have free and fair elections, we need to know the criminal antecedents of candidates. It was not there in any law. But the court said that it is necessary in order to have free and fair elections and transparency in elections, that the candidates' educational qualifications, his criminal antecedents, his assets and liabilities must be known to the people.
And therefore the court gave binding directions that look, Election Commission must ensure that this information is obtained on affidavit from all the candidates. Thereafter, the government tried to override that by passing a law saying that no, this is not required. And that law was struck down in the POCL case as being inconsistent with free and fair elections. So I am saying, my lord, the directions to be issued by this court should not be overridden tomorrow by a law passed by Parliament. Tomorrow they can pass a law saying that, well, government will enjoy complete control over this election. But that should not override, because these directions are being given to implement the basic structure of the Constitution, to implement the basic feature of the Constitution, which is free and fair elections.
Yes.
Now, my lord, so I have given the end of what I want. Now, my lord, let me take your lordship through the material. So, first, what happened in the Constituent Assembly? So, my lord, Dr. Ambedkar, at page 2 of the note, your lordship can just take the note because I have quoted almost.
You've seen it actually. You've seen the line of argument in the material.
Yes.
So Bangla, Saxena, the
Yes.
exchange between them,
Yes.
and then what are Dr. Ambedkar. So you've seen it.
So, should I read it, or I don't know whether.
You've seen it. Go ahead in your own way.
That's very well. So,
Yes. Go ahead.
yes, sir. But page 2 of the note, my lord, Dr. Ambedkar presented an amendment in Article 289(10) of the Constitution, of the proposed Constitution. The amendment vis-a-vis the appointment of Election Commissioner was as follows. The Election Commission shall consist of the Chief Election Commissioner and such other election commissioners, if any, as the President may from time to time appoint, and when other election commissioner is so appointed, Chief Election Commissioner shall act as Chairman of the Commission. Dr. Ambedkar, while presenting the amendment, said the House will remember that in a very early stage of the proceedings before the Constituent Assembly, a committee was appointed to deal with what are called fundamental rights. The committee made a report that it should be recognized that the independence of the elections and the avoidance of any interference by the executive in the elections to the legislature should be regarded as a fundamental right and provided for in the chapter dealing with fundamental rights. When the matter came up before the House, it was the wish of the House that while there was no objection with regard to this matter as of fundamental importance, it should be provided for in some other part of the Constitution and not in the chapter dealing with fundamental rights. But the House affirmed without any kind of dissent that in the interests of purity and freedom of elections to the legislative bodies, it was of the utmost importance that they should be freed from any kind of interference from the executive of the day. In pursuance of the decision of the House, the drafting committee removed this question from the category of fundamental rights and put it in a separate part containing articles 289, 290 and so on. Therefore, so far as the fundamental question is concerned that the election machinery should be outside the control of the government, there has been no dispute. What Article 289 does is to carry out that part of the decision of the Constituent Assembly. It transfers superintendence, direction and control of the preparation of electoral rolls and of all elections to Parliament and the legislatures of the state to a body outside the executive to be called the Election Commission. This is the provision contained in subclause 1. Then, my lord, Dr. Shibban Lal Saxena raised reservations about the appointment of the Election Commission by the President and proposed that Election Commission should be appointed by 2/3 majority of both houses so that the Commission enjoys the confidence of the House and not only of one party. That is at page 33-34 of the compilation. Dr. Ambedkar addressed the criticism of Mr. Saxena and conceded that his provision, that is appointment of election commission by President, does not contain anything to provide against nomination of an unfit person to the post of Chief Election Commissioner or any other election commissioners. In order to overcome the objections of
Dr. Saxena, Dr. Ambedkar added, subject to the law made by Parliament in draft Article 289, observing, quote, because, as I said, it is going to be one of your greatest headaches, and as a via media, it was thought that if this assembly would give or enact what is called an instrument of instructions to the president and provide therein some machinery, which it would be obligatory on the president to consult before making any appointment, I think the difficulties which are felt as resulting from the American Constitution may be obviated and the advantage which is contained therein may be secured. At this stage, it is impossible for me to see or anticipate what attitude this House will take when the particular draft instructions come before this House. If the House rejects the proposal of the drafting committee that there should be an instrument of instructions to the President which might include, among other things, a provision with regard to the making of appointments, this problem would then be solved by that method. But as I said, it is quite difficult for me to anticipate what may happen. And therefore, my Lord, the final provision which came was as it presently stands, that subject to any law made by Parliament. Unfortunately, no law was ever made by Parliament. Then, my Lord, I have mentioned the powers of the Election Commission, that they enjoy vast powers of all kinds. And of course, this court has also held in Shamsher Singh onward that Election Commission's powers are vast. They have complete powers to control free and fair elections, to ensure that elections on all matters. Therefore, mentioned provisions show that the power of the Election Commission extends to resolving disputes between various parties or adjudicating on a complaint made by one party against the other party. So the parties are stakeholders. The Election Commission play even a quasi-judicial role or a judicial role in determining disputes between political parties, which are headed by the Prime Minister, Leader of Opposition, etc. Then, my Lord, I have not mentioned it, Your Lordship may just note that there was a Citizens Commission, here Your Lordship may note, headed by Justice Lokur, which is at page 999 of the compilation, where the Citizens Commission, this is of last year only, they have mentioned that the Election Commission unfortunately is no longer functioning very independently. I don't want to get into that. I don't need to get into that. I'm just saying, my Lord, if the situation had been what was prevailing when in the time of Mr. Session or some years thereafter, this matter would not have assumed the kind of importance that it has today. Today, unfortunately, because there are, I'm not even getting into the question whether the Election Commission has been behaving independently or not, but certainly a lot of people, a lot of very respectable people have voiced apprehensions on this, that the Election Commission is no longer behaving very independently. So therefore, dates are being announced, that the dates for elections are being announced, which are known and announced by the government or the party in power prior to the Election Commission announcing the dates and so on. And all kinds of things have been happening. But it is not necessary for this court to go into that. It's enough for this court to say that, look, Election Commission's independence must be secured. At all costs, the independence of the Election Commission must be secured. And in order to secure the independence of the Election Commission, it is not enough for the Election Commission to have functional independence by way of government not having disciplinary control over them. It is also necessary that the selection of the Election Commission is by an independent body or by a neutral body, or certainly not controlled just by the government alone. So because government is certainly one of the stakeholders, it can't be. Thereafter, my Lord, there are reports of various commissions which I have mentioned.
Goswami Commission.
Yes, first is I have mentioned the Law Commission. They recommended, and this is at page 266.
Goswami Commission precedes the Law Commission.
Yes, long time back. Goswami Commission is...
And the 255th Law Commission report refers to the Goswami Commission.
Yes.
And it has also made its recommendation.
Yes.
In 2015.
Yes.
You're conscious of that.
Yes, yes. So 2015 is the last report of
That's
these, among these commissions, that is of the Law Commission. And that's at page 266 of the compilation. I'm not reading that, but broadly, my lord, what they said was
The need for
an independent selection committee, and they felt in their wisdom at that time that that may be secured by having leader of opposition apart from the prime minister, leader of opposition and chief justice. In a way, my lord, that is somewhat a neutral body. Neutral meaning that there is a counterbalance by way of leader opposition coming. But as I said, my lord, both the prime minister and the leader of opposition are stakeholders before the election commission. And if you apply the principle which was enunciated in the NJSC case, they said that the stakeholders should not have a say, because then there may be give and take and so on. So therefore, stakeholders should not have a say. They, of course, they have the right to send the name back if they feel that there is some problem with some particular appointment. But thereafter, if it is unanimously reiterated, they have no option but to appoint. It's another matter that today even that is not being followed.
there
But
the argument could be raised that in the case of appointment of judges,
yes,
part of the reasoning which weighed the court was that judges know who are the most suitable persons. At least that was a theory. They know whether a collegium with chief justice, they know the collegium system works on that basis. But here, when you're selecting, mostly it will be IAS officers, and the judges of the Supreme Court perhaps lay claim to know about the credentials, competence, character of the individual judges. I mean, of the individuals concerned.
in my respectful submission, my lord, yes.
There might
But-
be that issue.
Yes, no, I know that there is a slight difference, not identical. But this court, the Lord, deals with every kind of case, including such cases like appointment of election commissioners and so on. All these matters come to this court. Ultimately, my Lord, what has to be done? Somebody has to apply his mind to say, okay, all right,
what are the needs for having an election commissioner? What is the role that the election commission will be playing? And therefore, what kind of qualifications or what kind of things are required or recommended for such people? Politically neutral. Judges are at least politically neutral to the question. They are not stakeholders in elections. So therefore, in my respectful submission, my lord, the neutrality of the selection committee will outweigh. Of course, they can receive whatever recommendations, they can receive recommendations from the government, from the leader of opposition, etc. They can consult the government and the leader of opposition. Yes, for sure, they can consult them. They should consult them. Not just the leader of opposition, the other opposition parties or the other political parties, they can receive proposals from them. But the ultimate job of selection should be by a neutral body. And I am saying that neutral bodies that who are not stakeholders would be, of course, the judges, the judiciary, the collegium, would also be, in my respectful submission, the Chief Election Commissioner, would also be the Chairman of the National Human Rights Commission, would also be the Controller and Auditor General. So such people would be their constitutional authorities, constitutional or statutory authorities. And
We have two things to say.
yes,
There are no benchmarks for the purpose of making an appointment of a chief election commissioner
I don't think so.
under the constitution.
Yes.
So whosoever is considered the best suitable
Yes.
person out of the under the consideration
Yes.
can be appointed.
Yes.
Because otherwise you'll find everywhere there are benchmarks.
Yes.
You must have this age, this qualification, this background, whatever it is.
Yes.
Here this clean, it's complete clean.
Yes.
It is for the discretion to the committee, which the person they think proper, and a suitable person for this post can be appointed.
Yes.
There can't be anything more to that.
Yes.
Now, as you said, the stakeholders.
Yes.
Now, as my brother suggested to you, we are the stakeholders now when we are making appointment of judges and we are recommending name of the lawyers for judges.
No, no.
Now, from other corners, these are the grievances being raised against us.
The judiciary is not a stakeholder. Judiciary is not a
We are
stakeholder.
making appointment
No,
of
no.
the very persons which we know.
No. Stakeholders can
So
be,
people are making comments.
if there is
We may say
nepotism,
that
if there is nepotism, then
yes,
yes.
that is one thing. We may say that we are independent, we are examining in totality, we know the kind of a credentials, we know his caliber, we know his judicial approach. Correct? But still, we can't rule out the perception of the common man.
No, your lordship is right. So one of the things which your lordship mentioned is extremely important, transparency.
We have to.
Your lordship is right that ultimately it is the character, but we can lay down several safeguards to ensure that wrong people do not have to be appointed.
Suggest us.
Yes, sir.
safeguards according to you.
Safeguards are firstly, selection should be by a neutral body. This is the first safeguard. Most important safeguard. Second safeguard, selection should be with some degree of transparency. That means whatever their selection committee is there, whatever, whoever is the selection committee, the names of the proposed appointees or the shortlisted appointees should be made available to the public before the appointment is made. Because I say the same about judiciary also. I have said that, I have maintained this throughout, because what happens sometimes is people don't come to know that so and so is going to be appointed, and they may have some very relevant information about that person, which may disqualify that person from being appointed. So therefore, that degree of transparency is absolutely essential. That means you at least disclose before this appointment is finally made, you at least disclose the names of the proposed appointees. Who are the people that you are proposing to appoint? So transparency is another aspect which is very important. So first neutrality and second transparency. And of course, I say that certainly the selection committee should consult the government and the opposition, etc., whoever they can consult. Of course, the second best alternative is to select what the law commission recommended. That's the second best in mind. But the best option is to have a neutral body to select. Coming back, my lord, so the law commission said this. Then the first commission was the Dinesh Goswami committee, and they had suggested, that was in 1990, they had suggested Chief Justice of India and leader of opposition, and in the absence of leader of opposition, then consultation with the largest opposition group. That's the committee that they had recommended. Then came the National Commission to review the working of the Constitution, which was headed by Justice Venkatachalaya. They suggested Prime Minister, Leader of Opposition in the Lok Sabha, Leader of Opposition in the Raj Sabha, Speaker of the Lok Sabha, and Deputy Chairman of the Raj Sabha. One other thing which I should mention. In order to avoid arbitrary appointments or arbitrary selections, it is better to have a slightly larger body. For example, 3 is better than 1, 5 is even better than 3. So of course, it should not be so unwieldy, that it becomes impossible to convene their meetings and get them to function, etc. But
Three being the ideal,
five in my view.
no, three being the ideal number has already been pronounced upon in TN Sessions case. In TN Sessions case, you can see the discussion there. When the government changed it by the ordinance in 1993. Initially, it was only
Three
one
members of election commissioner.
election commission.
Ah,
If you make it a very unwieldy group, you will have possibilities of independence being compromised because of that. So the lesser number of people available for the powers that be,
so sure about that. I feel, my lord, of course, it should not be unwieldy.
it should not be unwieldy.
Should not be unwieldy. I agree with that. But one person, my lord, if you leave the discretion to one person,
That's what happened with.
there is a
Session.
much larger scope of arbitrariness.
That's exactly what has happened with Session. Some of the remarks made against Session in the Sessions case by the court, which led the government to actually constitute add the the commissioner, the election commissioner.
No, he was independent, but he was also very dictatorial.
Exactly.
He was.
There are so many aspects to be balanced.
Yes, your lordship is right. What I was saying was that in the selection committee, actually this question arose when we were discussing the draft of the Lokpal bill, etc. Who will be selecting the Lokpal? And therefore, I had always felt that the selection committee should be a sort of broad selection committee of maybe 7 people who should select the Lokpal. But, so therefore, the government may have one person there, the opposition may have one person there, but then 5 independent bodies should also be there, so that the dominant people who select are independent, not really the stakeholders, so to say. So, in my respectful submission, my lord, the ideal number of the selection committee for the election commission should be 5. It's not too unwieldy, and it will ensure that the arbitrariness is reduced substantially. So 5 could be 5 members of the collegium, 5 could be 3 members of the collegium plus, let's say, the outgoing election commission plus the Human Rights Commission.
You have made that point. You have understood your point.
Yes. So
now what more is it that you want to say?
So then, my lord,
you're relying on all the reports.
Now I want to read some very important observations in these judgments.
Yeah. So you have not yet taken us through the text of Article 324, which we will request you to do.
Yes, sir. Yes.
Only then we will have a.
Yes.
What are we doing actually?
Yes, my lord.
Because
Yes. There
is no challenge to the constitutional provision of being able to basic structure or anything of the kind. We have to take the constitution as it is, obviously.
Yes.
So we take Article 324 as it is.
Yes, my lord.
And try to do what we can.
Yes.
So let us see 324 in its and then.
Superintendent's direction and control of the preparation of electoral rolls for and the conduct of all elections to Parliament and the legislature of every state, and of elections to the offices of the President and Vice President held under this Constitution shall be vested in a commission referred to in this Constitution as the Election Commission. The Election Commission shall consist of the Chief Election Commissioner and such number of other election commissioners, if any, as the President may from time to time fix, and the appointment of the Chief Election Commissioner and other election commissioners shall, subject to the provisions of any law made in this behalf by Parliament, be made by the President.
So this is a key provision.
Yes, this is the key
So
provision.
your case is
Yes.
that as things stand, as it stood even at the beginning of the Constitution,
Yes.
the power to appoint lay with the President, continues to lie with the President. The President obviously means President acting on the advice of the Council of Ministers.
Yes.
So therefore, the Council of Ministers at present decides to appoint, and this power is subject to any law made by Parliament.
Yeah,
No law has been made. So there is a gray area, there is a gap.
yeah.
So there you bring in Vineet, that,
Vinit Narayan, Prakash Singh,
and then Vishaka also,
yeah,
where you can perhaps, the court can fill in the gap
yeah,
without doing violence to the terms of the constitution.
yeah.
This is what you are, sum and substance of your cases. Whether
Of
we
course.
should, whether we can evolve a system of appointment, having regard to the dire need for doing so, for the reasons which you have mentioned, till such time as the law is made, because we cannot possibly be ending up laying down. Even in Vishaga, the court said, lay down the guidelines till a law is made, and it took a good 2 decades thereafter, or perhaps even more, for Parliament to respond with actual lawmaking, which
course.
prevails today.
Of course, my lord,
That
if
is
you're,
a short area, that is an area where we can actually step in. This is what you are trying to say.
but the only thing is that,
We cannot say that Parliament is foreclosed from exercising its legislative powers phase to entry 72 of list 1.
I agree.
Yes.
Of course, if this court says that we are giving this direction, that this selection shall be by this kind of an independent or a neutral committee. Selection and appointment are slightly different. Of course, appointment has to be made by the president.
That's right.
But selection can be made by different committee. Then that law could also
That is a
provide.
grey area. That is the area
Yes,
where
that's the area.
we can perhaps step in.
Yes, correct.
Till a law is made by Parliament. Because
Alright.
we cannot possibly stop the Parliament from making a law. As to whether that law can be challenged separately, that's a different matter.
Yes, same thing happened with NJAC.
Exactly.
NJAC.
We can't stop them from making a law, but then if they make a
We
law,
made a constitutional amendment,
that's right.
and that was also struck
Absolutely,
down.
absolutely.
Same thing happened in that
Now you can
UCL and ADR. Same thing.
perhaps read Article 324(5).
Yes,
Yes, I may not read the whole of it.
yes,
324(5) also.
yes. That's important.
Yeah.
Subject to the provisions of any law made by Parliament, the conditions of service and tenure of the election commissioners and the regional commissioners shall be such as the president may by rule determine.
So pause for a moment. That's a law was put in place in the year 1991, as you know. They made a law traceable to conditions of service and tenure, but relating to appointment per se,
They didn't make.
relating to Article 324(2). No law has been made by Parliament.
Yeah,
This
that's right.
is what is perhaps the position.
Yes, correct.
Then the important thing is
Proviso.
the provisos, the two provisos.
Provided that the chief election commissioner shall not be removed from his office except in such manner and on like grounds as a judge of the Supreme Court, and the conditions of service of the chief election commissioner shall not be varied to his disadvantage after his appointment. So this provides for that functional independence,
That's right.
so that the government doesn't have control over his conditions of service or his removal, etc.
That's right. There's an appointment and removal. The appointment is governed by 324(2). Removal is already provided for in 324, and there is no scope for the court to say something contrary to what is expressly provided in the Constitution.
Right. And
So
so
we are
far,
concerned essentially with how you go about appointing the chief election commissioner and also the election commissioner.
correct.
We take it that's your
That's the
only short point is about the appointment.
correct.
We can't be ruling on.
No, in my petition, but in one other petition, I believe the issue is also about the rules, etc. In my petition, both petitions, the only short issue is regarding appointment.
So you've made these proposals, and then what is the state of the law in other countries? You have mentioned about South Africa, Ghana, in the US. You have given practices prevalent in these countries as well.
I have not really.
We have seen some of the other cases, like in the US, I think it has to be approved, president appoints, but it has to be cleared by the Senate.
Yes.
Correct.
Yes.
Now you take a case where
There are divergent models.
huh?
There are divergent models across the.
There are different models.
That's it.
Not exactly.
So in any case, my lord, here I am going purely by the basic principle which your lordship has laid down. That is, in the NJSC case where your lordship served, that look, judiciary has to be independent of the government because government is a major stakeholder.
That's right, absolutely.
Same principle I am applying here. Exactly the same principle. Election Commission has to be independent because government is a major stakeholder before the Election Commission. Just as rule of law and justice is a basic feature of the Constitution,
You have made that point.
democracy and free and fair elections.
Okay, then you could perhaps move on
Then,
to the decisions you want to lay out.
yes, my lord.
And then we can
First, this
move on to
is the SCORA, which I have quoted the relevant paragraphs in this. At page 6 of the note, Lord, at the bottom, no one can deny, this is the quotation.
Mr. Bhushan, give the citation.
Yes, the citation,
which,
that is 1993 4 SCC, page 441. And I am reading para 207, which I have quoted.
93.
93 4 SCC, 441. In my note, my lord, everything is.
Because the compilation containing all the judgments.
Yes, no, this judgment is not in the compilation.
We have a compilation given.
Acha, of the judgment.
Particular number of judgments which have been given, we don't know whether this is a part of it.
I'm not sure whether, this must be there.
Okay, just give us the citation.
1993
Yeah.
4 SCC 441. And I'm first reading, my lord, para 207.
But this is there in his note, which he has reproduced that.
That's good, that's good. So paragraph,
Paragraph 207.
you may indicate the paragraph,
Yes, yes.
unless you want to read
There.
it, just give us a paragraph, we'll go through it.
Acha, all right. 20,
We'll spend the.
all right, all right. 207.
Yeah.
And here they say why the appointment is essential, why the appointment cannot be controlled by the government, or that the government can't be the prime mover so far as appointment of judges is concerned. Why independent appointment is necessary for securing an independent judiciary. They
Yes.
say that very clearly. So 209, they say the aforementioned discussion, I'll just read this one sentence, leads to an inescapable conclusion that all the factors mentioned above coalesce to support the view that the executive will not be justified in enjoying supremacy over the opinion of the CJI in the matter of selection of judges to the superior judiciary. So, and then, my lord, they para 321,
Paragraph 321.
334,
Yeah.
and 334, one quotation which I'll just read, which is important. It is not the security of tenure provided to an individual judge which alone is the source of independence of judiciary, but there has to be an independent judiciary as an institution. The judiciary in India has to act as an impartial umpire to resolve disputes between governments and private individuals as well as between governments inter se. It also has to protect fundamental rights of individuals guaranteed by Part 3 of the Constitution. The courts in this country have already expanded the scope of judicial review by bringing in its ambit social, economic and political justice. Keeping in view the expanding horizon of judicial review, it is the paramount need of the time that not only the independence of the individual judge is to be secured, but the independence of judiciary as an institution also has to be achieved. The question that comes up, 335, the question which comes up for consideration is, can there be an independent judiciary when the power of appointment of judges vests in the executive? Same thing here with the Election Commission. To say yes would be illogical. The independence of the judiciary is inextricably linked and connected with the constitutional process of appointment of judges of the higher judiciary. Independence of judiciary is the basic feature of our constitution, and if it means what we have discussed above, then the framers of the constitution could never have intended to give this power to the executive. In fact, my lord, in the Constituent Assembly discussions also, the expectation of Dr. Ambedkar was that some law will be made to provide for some independent.
We are bearing that now.
Yeah. Mhm.
Next gentleman, you are
In the form, the Union Executive has vital interest in various important matters which come up for
You
adjudication.
know that we have seen that. Yes. So that-
Then the next judgment is
Yeah.
Roger Matthew versus South Indian Bank,
Yeah,
2026 SCC, page 1,
yeah. Paragraph?
about the tribunals. Paragraph 153
Yeah.
says, Roger Matthew, 2020, volume 6 SCC, page 1.
Now,
We are-
you take it that you will read each paragraph, each sentence of it, we will go through
All
it.
right,
But
all right, all right.
so that, you know,
So the basic point, the same thing they say about the tribunals,
that's it.
which they say about the judiciary. Then, my lord, in the second Skora case, that is the NJC case, 2016 5 SCC, page 1. Here, I have mentioned several paragraphs. I have reproduced several paragraphs which talk about the dangers of having this reciprocity. That is all right.